throw at us, we're open for business. I recently joined the firm in October after working for nearly 7 years at another Toronto-based insurance defense firm, and so far loving my time at SBA. So without further ado, let's get on to the presentation. Assessing housekeeping damages. Yes, I know what you're probably thinking. Housekeeping damages? Really? You're going to talk to me about housekeeping damage for 20 to 25 minutes? And yeah, the answer to that question is yes. Yes, I am. Now, I know it's not the sexiest of topics, but it's really important and actually kind of complicated. And I thought this would be a useful presentation because over the years, I've noticed that many adjusters and lawyers alike really don't know the ins and outs of housekeeping damages and what a plaintiff is actually entitled to. So what are we going to be talking about today? Well, today we'll be discussing the seminal 2009 Ontario Court of Appeal case of McIntyre versus Doherty. This case basically laid down the framework for housekeeping damages in Ontario and really the rest of the country as well. Then I'll be discussing the three main categories of housekeeping damages and provide some examples in the case law. And lastly, we'll set aside about 5 to 10 minutes at the end for any questions that you may have. You can submit this during the presentation in the Q&A section of the webinar. But before we do all of that, I'm just going to give you a brief primer on remedies, as this kind of lays down the groundwork for my entire presentation. So what are remedies, or what is a remedy? Well, when a plaintiff commences an action with the court, they are asking the court to order a remedy. Now, there are various remedies such as specific performance, injunction, restitution. Generally, in bodily injury claims or in tort claims, the plaintiff is almost always seeking the remedy of damages. Now, damages can be broadly grouped into two categories: pecuniary damages and non-pecuniary damages. Now, there are other types of damages, but for the purposes of today, I only be talking about these two. Pecuniary damages. What are pecuniary damages? Well, they are damages that are quantifiable. They are generally assessed on the basis of calculable losses, such as items as loss of earnings, loss of profits, cost of future care, as well as any other expenses that might be incurred as a result of the plaintiff's injuries. In contrast, non-pecuniary damages are damages that are not quantifiable. They are intended to be compensated. They're intended to compensate intangible losses such as pain and suffering, as well as loss of amenities or loss of expectations of life, or loss of guidance, care, and companionship. Often we see a non-pecuniary damages awarded on a global basis and not broken down into its component parts. And you'll see in this presentation that housekeeping damages can be both pecuniary award and non-pecuniary award, depending on what kind of damages the plaintiff is seeking. And we will get to all that in a second, but before I do, I just want to share a little bit of trivia for you. So, did you know that the award for housekeeping damages is relatively new to Canadian jurisprudence? It wasn't actually until 1979 that a common law court recognized this head of damages within a bodily injury context. This case actually was an English decision by the name of Daly v. General Steam Navigation Company. Now, prior to that decision, a plaintiff could not make a claim for housekeeping damages because there was no recognition that any loss of housekeeping was suffered personally by the plaintiff. However, and this is a big however and a big but, a husband could make a claim if his wife was injured and can no longer complete her housekeeping chores for her husband. This type of damages was called a loss of consortium, which literally meant a loss of obedience or loss of servitude. And this type of claim was based on the antiquated theory that it was the husband's interests that were damaged as a result of his wife's injuries. Now, even though I can't see any of you on it right now, I can sense that there's a collective eye roll after that factoid. I mean, you really can't make this stuff up, and it's just mind-boggling how chauvinistic the courts were at a time, especially given that this wasn't even that long ago, since 1979. So after housekeeping damages was recognized in 1979, it became a rather vexing issue for the courts. They really didn't know how to assess it. Was it purely a pecuniary award? Did the plaintiff have to incur housekeeping expenses to be awarded housekeeping damages? What happened if it was done for free by family members? Is it a separate non-pecuniary damage, or does it form part of a global non-pecuniary reward? So fast forward to 2009, the Ontario Court of Appeal tried to answer these questions in the case of McIntyre versus Doherty. This case dealt with the plaintiff, Claudia McIntyre, who was injured in a motor vehicle accident in 2000. She suffered from chronic pain, fibromyalgia, as well as depression and anxiety. In terms of functionality, she was capable of doing some light housekeeping, but relied on her family members for the more strenuous tasks like cleaning the bathrooms, doing the laundry, taking out the garbage. Very much a case that we deal with on a day-to-day basis. At trial, the jury awarded damages of about $55,000 for past and future loss of housekeeping capacity, as well as a separate head of damages, for $5,000 for past loss of housekeeping efficiency. Now, in this case, the award for loss of housekeeping capacity is considered to be a pecuniary award because it accounts for the housekeeping expenses that the plaintiff had to incur before the trial and will incur after the trial as a result of her injuries. The award for loss of housekeeping efficiency is a non-pecuniary award because it compensates for the intangible loss, which is the loss of performing housework efficiently. Now, if you're still a little hung up on the whole pecuniary, non-pecuniary distinction, don't worry, there's more to come. But first, I just want to dive into this appeal and the outcome of this appeal because it provides a good starting block for moving forward. So on appeal, the defendant challenged the award for past and future housekeeping damages. In regards to past housekeeping damages, the defendant argued that loss of housekeeping efficiency is not recognized as distinct non-pecuniary head of damages and should not have been awarded. They also argued that the plaintiff suffered no compensable pecuniary loss since her family members helped out and did the work for free. The Court of Appeal disagreed with the defendant and held that loss of housekeeping efficiency is recognized as a non-pecuniary damage. However, it should have formed part of the plaintiff's global non-pecuniary award for pain and suffering, not be given as a separate award unto itself. The court also disagreed with the defendant's position on the past loss of housekeeping capacity. They said that the plaintiff may seek a pecuniary award for past housekeeping loss, even if the work was performed by unpaid third parties, such as family members or friends. They held that these services have an economic value and can be measured in reference to replacement costs, i.e., the fair market value of that service. The defendants also appealed the award for future housekeeping damages. They argued that this award was not available to the plaintiff because there was no evidence that the plaintiff would ever hire or retain housekeeping assistants in the future. In response to this argument, the Court of Appeal said that it was unnecessary for the plaintiff to satisfy the court of any firm intention to employ third-party help. Rather, it was the plaintiff's discretion on how she spent her money and whether she will struggle with her housekeeping or seek assistance in the future. The court then went on to list 3 categories in which the plaintiff could receive housekeeping damages. These are work left undone, work done inefficiently, and work done by third parties. And I'll go through each of one of these in more detail. So a claim for work left undone. This can arise when the plaintiff may leave some or all of their housekeeping work left undone because of their injuries. Now, the purpose of this head of damages is to compensate for the loss of the benefit of having done the housekeeping, loss of contribution, and loss of the amenity of an organized household. Since these losses are intangible in nature, they are characterized as non-pecuniary damage. Now, just to throw a bit of a curveball at you here, the Court of Appeal also postulated that this head of damages could also be awarded as a pecuniary award. The rationale that they gave that it would recognize the economic value of unpaid housekeeping. They said that the denial of such award may be seen to unfairly diminish the contribution of those responsible for the bulk of housekeeping, which, as we all know, still largely is borne by women. So there's certainly a public policy rationale for viewing work left undone as a pecuniary award. With that said, Court of Appeal, being the Court of Appeal, stated that, treating work left undone as a pecuniary award doesn't actually fit neatly into the traditional view of pecuniary damages. As I said before, pecuniary damages are quantifiable in nature. For instance, if a worker can no longer go back to work because of their injuries, their pecuniary award is based on their lost wages. However, an unpaid homemaker does not suffer a loss of wages. So we would theoretically have to impute an economic value of their loss, which could lead to some uncertainty and a lack of uniformity depending on the specific factual scenario of each case. So what did the court ultimately decide? Was it pecuniary award? Was it a non-pecuniary award? Was it both? Well, they actually decided to pass the buck. They said that we're going to leave this issue for another day, for another court to decide. And I can tell you that that day has not actually come. We cannot find any case law that specifically addresses whether work left undone could be claimed as a pecuniary award. Also, I have not seen any plaintiff's counsel that specifically makes this argument either. So basically, as it stands, we know for sure that damages for work left undone is in fact non-pecuniary in nature. However, whether it is a pecuniary award is basically anyone's guess at this point. But I'm sure I think a good plaintiff's lawyer could probably make a convincing argument that it is compensable as a pecuniary award. So if you're anything like me, you're probably feeling like this guy at the moment. I know, like I said at the top, this area of law is a bit complicated and I just threw a lot of information at you, but bear with me. The rest of this presentation is much more straightforward. So second category of housekeeping damages is work done inefficiently or with increased pain. Now, this area arises when the plaintiff continues to perform the tasks, but with difficulty, requires more time to complete the tasks, or manages to get by completing the task, but in discomfort or pain. This loss is compensated as part of a non-pecuniary damages award for pain and suffering and loss of amenity. Specifically, it's intended to compensate the plaintiff for the pain and difficulty in persevering with their housework. Now, there are not a ton of cases that discuss this type of damages in any detail. We were able to find a recent Ontario decision of Rodriguez versus Pertel. In this case, the plaintiff was seeking $20,000 for past housekeeping damages. However, there was no evidence that she hired or relied on any third parties for help. Also, the plaintiff admitted that she was still able to complete her housekeeping tasks, but with increased pain. So the court rightfully characterized her claim as non-pecuniary in nature and valued her damages in this regard at $10,000. And this actually formed part of her global non-pecuniary award, which was $145,000. We found a similar case out of Alberta in Meehan versus Holt. Again, in this case, the plaintiff was capable of doing her housekeeping tasks after the accident, but with increased pain. Her award for work, she was awarded work damages for work done inefficiently, and this was valued at $5,000. And it formed her global non-pecuniary award of $90,000. So you can see that this head of damages does not attract a large amount of money. If it is awarded, it's likely also going to be a fraction of the plaintiff's global non-pecuniary award. Now, the third and final category is work completed by third parties. This is a pecuniary award. It's relatively straightforward. This award rises when a plaintiff incurs a pretrial out-of-pocket loss by hiring a replacement homemaker. The plaintiff is able to claim the reasonable replacement costs of the homemaker as a pecuniary loss. So if the plaintiff hires a Molly maid service for, let's say, $20 per hour, they are entitled to be reimbursed for those expenses. And as we said before, the plaintiff doesn't have to provide any evidence to show that they will hire any help. Also, a defendant is not allowed to deduct from the award any contingencies on whether help will be hired in the future. So you can't say that the plaintiff is only entitled to 50% of future housekeeping damages because there is a 50% chance that they will hire help. And lastly, as we said before earlier in the presentation, work done by family members for free is compensable as a pecuniary award for past and future loss of housekeeping capacity. So some of you might be thinking and wondering, if a plaintiff is able to recover damages for the gratuitous work of their family members, do these family members who commence a claim under the Family Law Act also get to recover the value of those services under Section 61? And the short answer is no. Under the court dealt with this issue in Farrer versus Gladys. They held that the rule against double recovery prohibits a family member from receiving pecuniary damages for the value of their services if, in fact, the injured plaintiff has already been compensated for those services. So, all in all, no double dipping. So an example of an award of this kind can be seen in the recent British Columbia decision of Kim versus Lynn. In this case, the plaintiff was seriously injured. She was only 27 years old with 2 dependents and a husband. She did not hire any external help prior to the trial, and her family took over all the housekeeping tasks after the accident. At trial, the court assessed the value of the family's help at $15 per hour, which they did recognize was actually on the low end of such services in the fair market value of things. Plaintiff was awarded a total of $418,000 for past and future loss of housekeeping. The court followed the decision in McIntyre, stating that there are many reasons why damages should be compensable where the family intervenes to help for free. They stated that this approach allows for the plaintiffs to take advantage of family benevolence without providing a windfall for the tortfeasor. It discourages the hiring of less satisfactory and perhaps more expensive substitute services. And it allows for a court to determine what services are reasonably necessary based on what services the family's members were prepared to provide. So it really kind of gives the roadmap for the court on how to assess the plaintiff's level of impairment and also need for housekeeping assistance. Now, another case that we found is on the other end of the spectrum. This case is of Luong versus Draper. It's another decision out of BC. The plaintiff sustained relatively minor injuries. And the court held that she was no longer capable of completing heavy housekeeping tasks on an indefinite basis. Examples of her impairment was that she could not move furniture, clean carpets, or move things into storage, kind of pretty minor and mild stuff. She was awarded a measly $250 per year for life, or about $6,200 in total. When we see this case, this is likely a type of, pecuniary award we expect to see in many of the run-of-the-mill chronic pain cases we deal with, where the plaintiff's ongoing impairment is with respect to heavy housekeeping tasks, and that's about it. So not too much in terms of damages award under this type of factual scenario. So just to recap, there are 3 ways in which a plaintiff can make a claim for housekeeping damages. 1, work left undone. This claim arises when the plaintiff might leave some or all of their work left undone. It's generally seen as a non-pecuniary damage award, but as we discussed, the Court of Appeal left the door open for the possibility that it could in fact be claimed as a pecuniary award. 2 is work done inefficiently. Plaintiff might leave some or all their housekeeping. They might be able to perform all their housekeeping, but in a less efficient manner. This is strictly a non-pecuniary award. It does not generally attract a lot of money. And lastly, work done by third parties. Now, in these cases, the plaintiff might rely on paid or unpaid third parties to perform some or all of the housekeeping. This is strictly a pecuniary award and is based on the services rendered and to be rendered. Remember, this claim is compensable even if the housework is done by family members and even if the plaintiff has no intention of even hiring external third parties. So there you have it. Those are the categories in which a plaintiff can claim housekeeping damages. And that concludes my presentation for today. I hope you found it informative and not too complicated. And if you really love this webinar and you want to take it home with you, please just send me an email. My email is on the slide here, and I'll be happy to forward you the slides. Now, just to wrap things up, I will open the floor to any questions that we may have. Doesn't look like anyone is asking. Oh, one question here. So I have one question. What is the largest HL award you've heard of? So housekeeping award you've heard of. Really the largest one that I've seen is that one from Kim versus Lynn. That's why I added it in. Um, you know, again, those housekeeping awards for, especially on the pecuniary side, are going to be quite big when you have a factional scenario where the plaintiff is relatively young and has sustained very, very serious injuries. So in that case, I believe her non-pecuniary damages award was also well into the six figures. So you get, she likely hit on every single one of the damages that we talked about today. Can you show the slide of the email address again, please? Yes, yes, I can. One second. This my computer works for me here. One sec. Oh, there we go. All right, so if that's all the questions for today, if you have a question that pops up later on today, or you maybe have a case that you're thinking about, let me know. Send me an email, and I can try to answer it for you. Also, I just want to let you know that we have some upcoming webinars in the next few months. We got one on May 5th by Michael Pierce. It's on the decision of Family and Children's Services of Larnack versus Co-op, and then I believe it's in June, we have Daniel Strigberger of our firm doing More Than a Feeling, turning information into evidence. I just want to again thank you for your time today. I hope it was informative. I hope you learned something, and I hope to hear from you again. Take care, everyone.